What do we have as an estate planning technique to make sure that the couple does not need to spend down all of their money while they're both alive? So this gets back to the very important estate planning tool that's called a durable power of attorney. What's a durable power of attorney? That is a legal document that you sign while you're alive, while you're competent, while you have capacity, and you grant authority to somebody else, somebody you trust, to make decisions for you on financial matters and on healthcare matters in case you can't for whatever reason. So how does that fit into protecting assets? All right, let's say you've come to our office and we've prepared for you the durable powers of attorney. One is for health, one is for finances. We like to separate out our durable powers of attorney. When it comes to protecting assets, we're talking about financial powers of attorney. So in your financial durable power of attorney, it's called durable because it stays in effect even if you lose the ability to manage your affairs. So it's durable. So in your durable power of attorney, you've designated your spouse to act on your behalf if you can't. Okay. What happens next? Let's say you're in a care facility, you have dementia. Why does this durable power make any difference? It's because your spouse now has the ability to do the planning that is available to qualify you for Medicaid, even though you have more Medicaid, more money than Medicaid says you can have. We're going to be doing a whole webinar on Medicaid planning and techniques. What I'm hoping to share with you today is why it's important that you have good, comprehensive, durable powers of attorney for finances that anticipate the possibility of Medicaid planning. Because as an elder law attorney, what I often see from other attorneys who don't have the Medicaid expertise is they do not include the necessary grants of authority that allow us to do Medicaid planning. So the necessary grants of authority in a durable power of attorney would include the property to revoke a community property agreement and to enter into a new property status agreement that says everything is the separate property of the well spouse, the community spouse. Other grants of authority include the ability to do gifting that exceeds the annual exclusion amount, which most people think of it as 10,000, then it went to 15, 16, it's slated to go up to 17,000 a year. When we're doing Medicaid planning, oftentimes gifting is something that we want to do. You're gonna say, Lynn, but gifting has a Medicaid 5-year look back. We can't do that, right? Not necessarily right, not necessarily wrong. Yes, there's a 5-year look back, but there's no 5-year look back between spouses. We wanna make sure that this spouse not needing care, all the assets of this community are owned by the well spouse. So we're going to need to do a separate property agreement, put everything into their name. Why do we need to do that? Well, because for the ill spouse to get on Medicaid, they are supposed to have only $2,000 in countable assets. We sure don't want the house in their name. We're going to want to quick claim it over to the well spouse, do a separate property agreement, move all the assets over into the name of the community or the well spouse, so that upon the 1-year eligibility review, the Medicaid spouse stays on Medicaid and the state never has a claim against those assets. So I have seen nursing homes and other people who are non-Medicaid attorneys get somebody on Medicaid, but they forgot to do all the work that has to be done to avoid the state's lien. So there's all sorts of things that I want to see in a durable power of attorney so that my hands aren't tied when I'm working with the other spouse to get the ill spouse on Medicaid. One of the things that I just want to share with you today, because people say, okay, we have 800,000. Our house is worth 400,000, and we've got 4,000 in investments. And Medicaid standards, just to share with you, they basically say you can have 55, 60,000 up to about 130, 135,000. That's all you can have. You can't have 400,000. So most people said that I talked to my friend or somebody at the church or this or that, and they said, I just need to spend down all my money. If that's the case, and if you hear that and you have the ability to share with people, there is something that's called a Medicaid-compliant annuity. So let's say somebody has 200,000 too much in countable resources, 300,000 too much in countable resources. Can they go on Medicaid? Can the ill spouse qualify for Medicaid? The answer is yes, they can. With zero spend down, they can keep all their money in the name of the well spouse. Well, I just said they can only have, 60 to 135,000. How does that work? We take the extra money, the extra countable money, the well spouse buys a Medicaid compliant annuity. By taking money and buying this annuity that Medicaid allows you to have, you've taken countable money, a resource, and made it non-countable, a non-countable asset. The state doesn't count this annuity. So you put the extra money in this annuity. Let's say it's 240,000 needed to go in the annuity. Maybe they did some spend down, repaired the house, did this and that. They don't have to spend down all their money. You take the extra money. In my example, I'm saying 240,000. You buy the Medicaid annuity in the name of the well spouse. Well spouse gets to keep all the money in the bank. It's a range between the 60 and 135,000, and they have a $240,000 annuity. Is that money gone? It's not gone. It will pay back to the well spouse over a period of 5 years or 60 months. I made it 240,000 because I can divide that by 60. So $4,000 a month, if I did my math right, comes back to the well spouse every month over the next 60 months. And they do not need to take their income or their annuity money and pay for the ill spouse's care. The state pays for the care and by the ill spouse's income, and the state pays the rest. Well spouse gets to keep all the assets, gets to keep all the money that comes back from the annuity, didn't have to spend it down, and this couple never loses their house or any other asset that they have to the state when the ill spouse dies. So these are durable powers of attorney, and to do these kind of very effective strategies, they need to be the durable powers of attorney that an elder law attorney would prepare, because we know what Medicaid's rules are. And so we include provisions that a Medicaid planning attorney would include, and an attorney not familiar with Medicaid likely won't include. So both spouses are alive, ill spouses on Medicaid, the couple got to keep all their money. Notice I used the couple that had 800,000. I did not use in that example the couple with 3 million. Why is that? Because I would not recommend that strategy to the couple that has $3 million. It simply doesn't make sense from a financial investment perspective, from a Medicaid annuity perspective. It, in my opinion, would not be appropriate, and I would not implement it. So that's what I mean by I'm very transparent and candid with my clients. I recommend it if you're at this level, not if you're at that level. All sorts of various factors go into the analysis of what is an appropriate Medicaid planning strategy. All of that aside, I used examples to show you what could be done, but the point of it isn't the Medicaid strategy. I will talk about that at a different time. The point of it is to do this strategy, I, as the Medicaid lawyer, needed to have the right powers of attorney in place. And I don't always have those in place if they've been prepared by a different law firm.